Okay, so we're going to talk about the concepts in week 3. And I'm still not moving my head 100% of the way. So if you see grimaces of pain or the inability to move very quickly or far, that's why. All right, so we're going to talk about 3 things. Separations. And your book talks about separation agreements. We're really going to talk about the concept of the legal separation, which is a bit of a misnomer. And then we're going to talk about annulments, and then we're going to talk about divorces. They are essentially the 3 basic ways that you can get out of, that's Buster, he's always just on me 100% of the time, sorry, of a marriage. And they're 3 different factual scenarios, and they have 3 different outcomes as well. Essentially, a separation is just a separation. It's not permanent, and it's pretty rare. An annulment is a judgment that the marriage never existed, and a divorce is a divorce where the marriage is ended. It did exist, but it's ended. Okay, so the first thing we're going to talk about is a legal separation. A legal separation is where the parties are separated legally, but they're not yet divorced. And maybe the plan is that they will be. And it doesn't happen very often because people just typically get divorced. And if you want to get divorced, you get divorced pretty quickly, or as quickly as you can, or as soon as the property is settled. But the legal separation doesn't happen very often. It happens during the pendency of the litigation, and usually the litigation is over pretty quickly. But there are a few reasons that we allow a legal separation, and some consequences to it, okay? So legal separation would be written up, and it would be submitted to a court, and the consequences of it are that the minute that legal separation takes place, and I'm talking about the formal separation. There is an informal separation that starts the clock statutorily towards divorce. We'll talk about that in a second. But a legal separation is 2 people have sat down, they said, we want to separate, we don't want to be a married couple anymore, so we're going to file paperwork legally separating us. Does a few things. It terminates that duty to support, except for that which is decided by the court. If the court determines that there is duty to support because of a financial difference in the parties. But typically, new duties to support do not arise. And it stops the clock in a community property state on marital property. So, if we've got a community property state for terms of property or property distribution in a divorce, the minute that legal separation takes place, we start accruing individual debt and individual wealth. That legal separation keeps our finances separate. That's the consequence. So, why do this? Most people temporarily do this, pending a divorce, but the other issue is that sometimes people want a longer separation than is required by statute. Typically, that's for purposes of insurance. If insurance can be is necessary, let's say you've got one spouse who is undergoing cancer treatments, and they're going to need health insurance because they're on their partners, their husbands, their wives' health insurance. Because of those reasons, they may want to stay separated for a while, so that one person can benefit that. The other is a religious reason. Some people cannot get divorced because of religion, choose not to get divorced because of religion, but they have a legal separation, so they're protecting their own assets separately, even though they're not living traditionally like a married couple would. That's legal separation. I want you to contrast that with the informal kind of separation that happens before a divorce. Most statutes, and we will look at these statutes in detail at some point. Everything is statutory when we talk about divorce, the basis for it, how it happens. In order to qualify for a divorce, you need to first separate. That does not mean you need to move house. That does not mean that you need to live in separate houses. You can be separate in the same house. In fact, we're in a pandemic. I know this is not news to most of you. How many people do you know, if they're living with a family, a husband, maybe children, they decide to get divorced, can afford to move out into a new apartment now? Right? So that informal, let's call it, separation is what starts the clock on most divorce statutes. And it does not mean that you have to live in a separate house. So let's say husband takes the main floor, wife takes the basement, and they stay not completely physically separated, but they're not sharing a bed, they're not sharing a bedroom, they're not sharing meals. And the date that happened, which sometimes we look at the date they last slept together, sometimes we have more factual determinations than that, but you'll allege in the petition, we were separated as of X date, and the statute allowing you to get divorced will run the time period from the date of separation. Let's say it's 60 days. I think in Indiana with no kids, it's 60 days. So that date of separation is not the same as a legal separation because you don't have to file paperwork to start that. You just allege to the court, my date of separation was December 1st. So 60 days passed. What does that put us at? February 1st, let's say. I'm not doing the math. You allege that separation period in your divorce proceedings. That separation is more informal. But the true legal separation is pretty rare. That being said, just because I think it's important, a separation agreement, typically, your book calls a separation agreement, what they really mean is more of the agreement to end the marriage and how we're going to split up the property. What I'm calling a separation agreement is a document you file that says we are legally separated but still married, and you memorialize that with the court for purposes of property protection, and it's a legal separation, and it's pretty rare. But there are also, in that period of separation, between the time that you decided to get divorced and the divorce is final, that informal separation, there are some documents that you also might file with the court to protect your property. One might be called a protective order. It's not about abuse. That's very confusing. Different states call it different things, but in Indiana we call it a protective order. What that means is, remember we talked last week about community property? Who owns the property of a marriage in a marriage? Well, in some aspect, both of them do. Either they both own the whole thing, or they each own 50-50, what have you, right? So, we get separated. He cheated. I'm spiteful. I immediately drain all of the money in our bank account. And it's money that he put in from working because I lost my job 6 months ago. I didn't want to work anymore. We don't have any kids, so I'm not staying home taking care of them. And I sold his Corvette. Hey, he bought it during the marriage. Marital property, fair game, right? Yeah. Unless you get a protective order. And sometimes they're called provisional orders. Sometimes we might call that a separation agreement, but it isn't really. Those protective orders say, we agree that we are not going to waste marital assets. And so during that period of separation, that's one thing that might be filed. Another provisional order might be a temporary order for custody, child custody, or a temporary order for who's going to possess the home. If they can't live together under the same roof, they might have a temporary order. Hey, we agree that husband is going to live in the home, wife is going to get a new apartment, and we agree that he's then going to pay the mortgage, and all of the equity earned from the time of the separation forward is 100% the husband's because he'll be paying it all, and wife is absolved of that. So those provisional orders can happen when we are separated awaiting a divorce, and they protect us, and they're a really good idea because until one is filed, marital property is marital property, and you can lose a lot of money that way. So if you've ever heard to keep a spare bank account of your own that your spouse doesn't know about, practical considerations aside, legally that doesn't so much protect you because during the course of the divorce you're not supposed to hide assets from each other, and that can be problematic, as we'll see in some cases later. But it can be protected, the marital assets can be protected with one of those protective orders. Okay, let's move on to annulment. Have you ever heard anyone say, I'm just going to get it annulled? So, true story. My third year of law school, it was sleepaway school. I was in Pennsylvania, states away from my family. and living in an apartment complex, and one of my neighbors who was also a 3L, she had all these boyfriends, and I was like, she also has a fiance. And I remember she was real open about what was going on, and she said, yeah, I'm gonna marry him. I think she said something to be the equivalent, I think he'll make a good first husband, and besides, if I don't like it, I'll just get it annulled. We've all heard somebody say that, right? And I was like, you took family law, you know better than this. No, you're not gonna get it annulled, because that's a misconception. You cannot. You've heard all these situations, right? Well, if it's less than 30 days, if the marriage isn't consummated, if, we can get it annulled. Now, I will say that I've heard some really strange stories coming out of Las Vegas. And Nevada rules, kind of interested to look into this. Never have. But Nevada rules might be a little bit different. Let's put the drive-through marriage chapel by the Elvis Presley impersonator aside for a moment. In most other states, an annulment happens rarely. It happens under these circumstances. Remember last week when we talked about void versus voidable marriages? That is when you get an annulment. An annulment is a judicial determination that the marriage never existed, not a divorce. So, the annulment happens with void marriages, so bigamous marriages, marriages that were void ab initio, void from the start, right? And you might say, well, if it was void, if it never happened, why would you need an order? And I think we talked about that last week. Well, it's because to the outside world, it did exist, and you definitely need a court judgment to say, nope, it didn't. Get her name off all of the property, whatever you need to do in that aspect. But if you need an annulment because the marriage never existed, you were most likely in a voidable marriage. And that occurs generally for people who are under the age of majority. So people who are younger than 18, either when they got their parental consent or defrauded the court, showed a fake birth certificate that had an inaccurate date of birth on it. So you could annul a marriage, potentially fraud. You could annul a marriage based on fraud. It would have to be pretty devastating fraud. It is not enough to say he lied to me. He was a cheater and she was a cheater and a whatever. No, that's not enough. Fraud in the inducement is not enough, but fraud in fact, if you I don't know, believe you're signing a something and it's a marriage certificate, might be fraud, might be void or voidable. That's when you get an annulment. And that also is pretty rare. Even though we hear people talk about getting marriages annulled all the time, just not quite as often. All right, so now for the main event, let's talk about divorce. There are traditionally two different kinds of divorces. Historically, they were fault-based. Currently, they are no-fault-based. Now, many states still have fault-based statutes on their rolls, but they don't get used very often because they are definitely hard to prove. So, if you have seen the show Mad Men, or you know the lead character, Don Draper. Don is a charismatic, good-looking, I'll be very honest, John Hamm is my favorite movie actor of all time. He's a beautiful man, right? So, John Hamm's character, Don Draper, is a advertising salesman, and he is a philanderer to the highest degree. So Betty, his long-suffering wife, goes to, I forget which season it is, but she goes to a divorce attorney. And she goes into the divorce, and I think they're even smoking in the office, which is great. Like, she goes to the doctor and they're smoking. It's fantastic. So she goes to the lawyer and she says she wants a divorce. And the lawyer, quite rightfully, is giving her advice saying, I don't think it's going to happen, because it was in the 1960s, right? And so they only had fault-based divorces. Fault-based divorces are given when someone in a marriage has done something wrong, and they are basically in 4 categories that all start with the letter I, so they're really easy to remember. Now remember, your mileage may vary in a particular state, and we don't typically do this anymore. But fault-based divorces were because one of the two people in the marriage had done something wrong, and that means the other has the right to ask for a divorce. Now when Betty goes to the lawyer, she says, well, I want a divorce. And the lawyer says, well, why? What gives you the grounds? So, well, infidelity. Everybody knows he's cheated for years. And if you watch the show, yeah, everybody knew he cheated for years. So the most recent time he was caught, she says to go to the lawyer. And the lawyer's like, well, how are you going to prove that? Is she pregnant? Well, no. But everybody knows it. He's like, that's not enough. And he's exactly right. So fault-based divorce, whatever the ground of those 4 I's, which we'll get to in a minute, are, had to be proven significantly. Like, someone who's not the spouse catches them in the act of infidelity, or someone has borne a child. This is another one of my tales. This is Simba. He's a stone cold murderer. Which is why we don't have any mice. If you had a fault-based divorce, the proof level was significant. And those 4 I's were infidelity, to prove the spouse was unfaithful. Incarceration. The spouse had to be incarcerated typically for a period of 2 years or more. Insanity. They had to be adjudged insane and committed to a mental institution. And impotence. Inability to have children. Now, what do those 4 things have in common? Why were they the fault-based divorce? Well, pre-1960, women didn't have the rights that we do today, and they were seen as preserving, They were seen as preserving the rights that women had in a marriage, which were, what? Some level of property protection and children, because those children were what was important about a marriage. And there was a case either in this week or last week where the wife was pregnant when they got married, and there was a whole bunch of testimony. Oh, he's rubbing on the tripod. That's great. He's going to knock it over in just about a second. About whose child was who and when they stopped having sex. And there was a note. It was a 1962 case. I think it was this week. Well, obviously this isn't the child of the marriage, because they clearly did not have sex before getting married. Okay. So, all of those things. If someone is incarcerated for over 2 years, you can't have a child in those 2 years. And that was a long time back then. If someone is insane, unlikely, especially if they're committed to a mental institution, for them to have a child. Impotence, the same thing. I don't know the history of it. I'm assuming it applied more so to the male half of a traditional marriage. Can't have a child. Infidelity. Can't have a kid with you if he's impregnating someone else. And so all of those things happened. There also was the mental cruelty. Extreme mental cruelty may be a fault-based ground as well, and that's a potential 5th basis as well. So those 4 I's plus mental cruelty were the fault-based reasons for divorce. Shy of those, and shy of significant proof on one of those, you could not get a divorce, which is why that lawyer told Betty, sorry, do the best you can with what you got, because that's it. That was fault-based divorce. Historically, that was the law for many, many, many years. Now, women have the right to vote, have a credit card, have property in our own names, and not everybody has children. It's not the same financial picture. And divorce has changed as well. Divorce is now what we call no-fault divorce. Every state has a no-fault divorce. No fault means you do not have to prove the other party was at fault. You have to prove that you don't want to be married. That's it. The other party can want to remain married. Too bad. If one party wants a divorce, they get it. That's it. And we call it various things in different statutes. Sometimes it's the marriage is irretrievably broken. Sometimes it's we have irreconcilable differences. That language will vary from state to state, but what it means is one party no longer wants to be married. And this makes a whole lot more sense too. It may be less likely, or it may be through other legal mechanisms that a same-sex couple who can get married would have children now. Impotence in a same-sex marriage doesn't have the same meaning when we talk about children, or insanity. All those things don't apply in the same ways anymore. Or even to different sex couples where reproductive technology is potentially can overcome some of those fault-based grounds. So that makes a whole lot more sense. But one party alleges the marriage is irretrievably broken, we have irreconcilable differences. They're saying they no longer want to be married. And as long as the statutory grounds, and we'll talk about those, I think, next week, are met, they get their marriage. They get their divorce. The other party can drag it out when they want to, but they can't keep the first party from getting a divorce. They used to be able to in that fault-based system. So what are the consequences? Divorce is easier to come by. It's easier to prove. If you meet the statutory requirements, you get a divorce. I used to know when I used to practice in Norfolk, in a neighboring jurisdiction, Virginia Beach, there was a permanent clerk, not a one-year clerkship, a permanent clerk hired, and all this person did was go through divorce petitions. And she would hold a petition up to the statute and check off every allegation. If it wasn't perfect, it was sent back, but if it was, it got granted. If every statutory ground is made, and you just have to allege a lot of it, I suppose someone could say, well, no, we weren't really separated on December 1st, it was December 15th. Okay, I'll wait 15 more days. You still can't keep me from getting a divorce. So all of those things are memorialized in your no-fault statute, and when you follow it, you get divorced. That's it. Now, there are some movements to change that. There are some states that have a second tier of marriage. It's supposed to be more difficult to get out of. Sometimes it's called covenant marriage. Sometimes it's just a religious component, but sometimes there's also a statutory provision allowing for this stricter kind of marriage. There are all kinds of issues with that relative to abuse and coercion and all of that. And it's pretty rare anyway. But it's easier now to get divorced because of no fault, and that's been around since the 70s, 80s, and it's just proliferated. It's the law, and most people get no fault divorces. Now, what that means is that a lot of those things that make us want to get divorced are irrelevant. So, you want to get divorced because your spouse is cheating on you. Historically, that would have been a grounds for divorce. Relevant. It all comes up. Now, divorce is no-fault based. So, evidence of cheating or incarceration or insanity is completely irrelevant. There are some states, specifically more community property states, that may use some of those fault-based things to determine property distribution, but many don't. For instance, in the state of Indiana, where I have practiced, those things are irrelevant. She can be the worst creature on the planet, and she probably is because you want her butt out of the house. But it's irrelevant to getting a divorce, and most of the time, not always, but most of the time, it's also irrelevant to the property distribution later. Can it potentially be used in child custody? Yes, if her or his awfulness bears on what a parent they make. Yeah, that can be an issue. But most of the time, those fault-based things that may make us want to seek a divorce are irrelevant to the divorce itself. So that's legal separation, annulment, fault and no fault-based divorce in a nutshell. We will get to some of the cases later on, and I may have a supplement That's about my limit of pain tolerance for this, but not the subject matter. I think it's fascinating. But we will pick up later on, ask any questions in the question board, and work on your discussion board, and we'll go from there. Thank you for your patience.